you have to defend the whole thing because there might be indemnity for the covered claim, and the mere presence of uncovered claims within that lawsuit doesn't make
Counsel, in that regard,
yes, sir.
The Second District noted in Ware Carroll Porter versus American International Specialty Lines that the duty to indemnify cannot exist if there is no duty to defend. Do you disagree with this statement?
I think there's cases that go differently than that. We've cited a few of them in the brief, but as a general proposition, I don't disagree with the statement, and I don't think that does any injustice to this case. Had there been a duty of defense, again, we have to back up because there was no duty of defense in this case, but had there been a duty of defense, it's our contention that the allegations, as we've set forth and shown to court in our briefs, in both the reply brief to Airwood's brief and in our initial brief, where you can find the allegations in the second and fourth amended complaint that would state a claim that would be within the scope of coverage and outside of this exclusion.
Bottom line here, though, can't you look at both lawsuits and say they were both related of an overall scheme to take over marketing specialists, business, business?
No, sir. Certainly, the underlying litigation, you can say that. You can't say that with respect to the turnover suit. Again, the turnover suit, and we addressed this and the law on this in the reply brief, more specifically to Airwood, because the law on what a turnover suit is that it is a unique creature of bankruptcy law that requires a ministerial determination. That is to say, the only wrongful act within a turnover suit is the mere possession of property that belongs without dispute to the estate. So there didn't need to be anything wrongful, and there wasn't anything inherently wrongful with any of Acosta's conduct alleged in that turnover suit with respect to hiring the marketing specialist former employees or servicing their customers or any contact Acosta had with marketing specialist officers and directors. But when we get to the underlying litigation, the very stuff that at the time marketing specialist was asking us to do at the time of the turnover suit, that stuff became what the underlying lawsuit's claims were all about and what got litigated in that case.
So what it comes down to, if I understand your argument, is that because Acosta was not accused of a wrongful act in the turnover suit, it could not be a previously made claim. I mean, doesn't that what it comes down to? Because you're talking about basically the same kind of facts. You're talking about trying to, get their business. I mean, I think that's really not in dispute. But it seems like the core of your argument is that what previously happened was not a wrongful act on the part of Acosta.
While ultimately that the trial judge in the turnover suit found that there was no wrongful act on the part of Acosta, that's not my argument, so I don't want to.
Well, help me here.
Yeah, I will.
If he had found that there was a wrongful act on the part of Acosta, would you be standing there?
Yes.
And help me with that.
I will, Your Honor. In the turnover suit, the wrongful act was possession of property belonging to the estate without regard to how it came into your possession. That is what a turnover suit is. And any claims that were connected with the loss in our lawsuit that had to do with possession of tangible personal property, we would acknowledge we would have a problem on that on the basis of this exclusion. Because the purpose of the exclusion, you don't want to insure the house on the ground.
But there's some of that tangible personal property involved, laptops, computers. In terms of the information that was gleaned from the computers, would that be relevant to the second lawsuit?
Jerry Alexander, when he testified, he was the author of the second lawsuit, said he wasn't asserting claims based on laptops or their journals. But even putting that aside for a minute, the record evidence of what was being litigated in the underlying lawsuit was clear that it had nothing to do with possession or gaining information. It was the relationships. There was this group of employees who had relationships with the manufacturers. And by Acosta hiring these former employees and beginning to service these manufacturers in the days following marketing specialist bankruptcy, even though it was done with the debtor's request, the creditor's trust said, by doing that, we got the goodwill, we got the relationship.
Would you agree that in some circumstances, an exclusion may be deemed applicable based on the pleadings alone?
Yes, sir, I would agree with that.
You're down about 5.5 minutes.
Okay, I would just briefly like to get back to the loss issue, just to remind the court, we talked about this in our brief, and this is at supplemental record 293 to 302. There is when National Union initially declined coverage in this case, National Union declined coverage as to Acosta, but they accepted coverage as to one of the directors and officers. And when they did that, and this was based on the second amended complaint, which had 27 counts in it, National Union said, we reserve National Union's right to allocate defense costs and indemnity, if any, for this claim between covered and non-covered parties and claims. Clearly, they were recognizing that one lawsuit, like this second amended complaint, could have multiple claims, and there would need to be an apportionment and allocation between the covered and uncovered. I'll reserve the rest of my time. Thank you.
Good morning. May it please the court, my name is Anthony Russo and I represent Arrowwood Indemnity Company. I have 10 of the 20 minutes for the athletes.
Again, I'll try to remind you, but you're over the point.
Yes, Mr. Jeffrey Cohen represents National Union. He'll take the final 10 minutes. There is one critical point that I wish to make to the court in these 10 minutes, aside from answering the court's questions, and that is to explain that both the complaint for turnover and injunctive relief that was filed by marketing specialists against Acosta in the bankruptcy petition, as well as the complaint for damages, the fourth amended complaint filed in the federal district court, both arose out of the same facts or the same related acts, as those terms are defined in this policy. And arising out of is important because it's found in exclusion 4E that we rely on. And the term arising out of is also the centerpiece of the Florida Supreme Court's decision in Taurus from 2005. And that's central to the decision of the trial court and our position. Arising out of, as the Supreme Court said on the final page, is to be given a broad interpretation. And it includes...
You know, it's interesting to me, bankruptcy is in a world of its own. I mean, the bankruptcy litigation, turnover suits, those kinds of things.
Yes.
It really doesn't seem to me that we're really talking about the same kind of wrongful act. Does that make it different?
What act, wrongful act, is a term of art defined in the policy. So it's whether we think it's wrongful or the judge found it's wrongful is irrelevant. What matters is what is alleged, and does it match what is the definition in the policy. And if you look at Record 92, I believe it is, in the policy, the National Union policy, wrongful act as to the company is defined as any act of the company. It's a little bit different when it's referring to the specific directors and officers. And
How is it referring to the first suit as the release? Do you agree with that?
I've seen it described that way. I've seen people use that. I don't know how lawsuits are described as friendly. What Acosta was accused of doing was looting. Well, that word was not used in the turnover suit. Taking these, the paper files, the hard copy files, and the computers, and interfering with the business of marketing specialists.